with more. Jessica, what is the opinion from the court?
Poppy and Jim, the court issuing that landmark ruling that this nation has been bracing for, and the Supreme Court has overturned Roe v. Wade, that they have eliminated the constitutional right to an abortion, and at first glance, this opinion is very similar to that draft opinion that we saw just about a month and a half ago at the beginning of May. So what we're seeing at first glance here is that this is a 5-4 decision. This is an opinion written by Justice Samuel Alito, joined with those other conservatives, Justice Thomas, Gorsuch, Barrett, and Kavanaugh. The Chief Justice John Roberts not joining in the opinion, but joining in the judgment, meaning that he agrees that the Mississippi 15-week abortion ban should be upheld, but not agreeing with this sweeping proclamation that Roe v. Wade is overturned. We are looking into this opinion, but this will have immediate effects here. By all estimates, about half of the states are expected to eliminate the right to abortion. We've got about a half dozen states that have so-called trigger laws that their abortion bans will go into effect either immediately or within the next 30 days or the next few months. And then we have about a dozen states with so-called zombie laws. Those were actually abortion laws that were on the books before Roe v. Wade in 1973 that will then go back into effect. On the flip side, there are about 16 states in Washington, D.C. that have sort of amped up their abortion protections. So they're expecting potentially to see an influx of patients coming into their states to actually get abortions for people who are living in states that will soon not be able to get abortions. So this is, in fact, a landmark ruling here. This is overturning nearly 50 years of precedent that was first established in Roe v. Wade and then affirmed in Casey, the Casey decision in 1992. Those opinions, and for 50 years, there has been a constitutional right to an abortion from the Supreme Court. Women have been able to get abortions. The state has not been able to restrict abortions up to the point of viability, about 23 to 24 weeks. But now this court upending the past 50 years of history, and again, is looking very similar to that draft decision, again written by Justice Samuel Alito. In the draft decision, he said that Roe v. Wade was egregiously wrong. So we're going to go through this opinion and look at how it compares. But if it is similar, which it appears to be, he'll talk about how there's really no historical precedent for the Supreme Court, upholding the right to an abortion, and that this should really be left to the states. This is what this opinion will do. It will say that the Constitution does not guarantee the right to abortion, and it's left to the individual states. And one last thing, guys, Justice Alito had said in that draft opinion, and probably says it in this one as well, that this is just too divisive of an issue to kind of glean from the Constitution when it isn't specific about abortion and about the right to an abortion. And this is something that needs to be decided by individual states where people have the power to vote in their elected representatives. And the court here saying that that power should be returned to the states. It will be returned to the states now that the court has overturned Roe v. Wade.